That's the backup recording started, but Mark will confirm when the live one is.
Okay, that's the live stream underway.
Okay, thank you. Welcome to the meeting of the Ad-Hoc Scrutiny Panel on Antisocial Behaviour. First of all, I want to ask if anybody wants to speak, if you just raise your hand so that I can see that you want to speak. Councillors aren't restricted to the number of questions or the length of time they have to speak or anything. They can speak as long as they need to and ask as many questions as they need to. Can I ask that officers give their role and their name for the recording as well, please? So first of all, we'll do the roll call.
Thank you, Chair. Councillor Benison?
Yeah, I'm here.
Councillor Davis?
Yeah, I'm here.
Councillor Flanagan?
I'm here.
Councillor McPherson?
Here.
Councillor Tolmash?
Yes, I'm here.
And the sixth member is Councillor Gibson, who I don't think is present, Chair. Thank you.
Thank you. Do we have any apologies or substitutions today?
No, we have no apologies.
Thank you. Are there any declarations of interest? No, we'll move on to the meeting, the minutes of the meeting of the 21st of December. Is there anything any members want to raise from these minutes? No. Right, we'll move on to the item 4 of the agenda, the report from Bryony Monaghan. Bryony, do you want to speak to your report, please?
Yes, thank you. It's Bryony Monaghan, Interim Head of Education and Independent Lead Officer for the panel. So the report just provides for the panel a bit of a summary of the planned activity for today, with recommendations to note the information provided on streamlined evictions and sensitive lets, agree plans for further consultations with the Housing Advisory Group, and agree next steps for the panel, including agenda items for the next scrutiny panel on the 2nd of February and the beginnings of development of a report to Stirling Council for the meeting of the 3rd of March.
Thank you. I had a couple of questions on the report on page 6, and it was about the questionnaire. Where was it? I haven't actually seen that on any of the council social media yet, but I'm of the understanding the survey is has been put out for the public. Can you tell me how this has been publicised to let people know it's around? Anyone who can answer that? Thank you. Thanks, Stephen. Thank you.
Yeah, thanks, Councillor Benison. Yeah, it's not up on the platform as yet. We'd sent an additional clarification to members, which I think has been accepted in terms of an additional question. My intention is that it would be coming out onto the platform in the next couple of days. We've prepared a press release, which we can share with members for consideration as well, which would help to publicise it further. So, as I say, press release, as in addition to social media release, in terms of to raise awareness of the ability for people to answer the survey. We'd also put it out to our tenants groups that may have an interest in filling the questionnaire out as an organisation as opposed to just an individual as well.
Thank you. How long is that questionnaire available for?
I don't think we've agreed an end date for that. We just have to take cognizance of the fact that the final report would need to be informed by the survey. So I think we'd be looking at sort of mid-February for the final date. So we just need to get some clarification about reporting timescales for the council meeting on the 3rd of March.
Okay, thank you. Councillor Trauma.
I just wanted to know about the press information. Will the press information talk about this panel and the reason why it was set up? Because clearly this document to engage Stirling needs to have a background. So I just wanted to know what the background, what was going to be said about the reason that, okay, the panel is actually being set up. Thank you.
In terms of the, I mean, I've had a brief glance at the draft press release that's been worked up. It's something that we could share with panel. It's relatively short, but I suppose it's trying to grab people's attention as opposed to go into a great amount of detail. But there could be some additional context as to why we're asking for the information and the reason of the establishment of this panel. So we could potentially add an additional paragraph, work something up there, and potentially pass that on. Mark's also on the call, so you might have some suggestions in terms of additional work to provide more context around the press inquiry. Sorry, the press release. Sorry.
Yeah, thank you. Bryony, did you want to come in there?
Just quickly to say, it does briefly indicate that the reason for the survey is because there is a panel with a focus on these issues, wanting to make changes and improvements to this area of work. So that is briefly stated, and there will be, as Stephen has said, the chance to review and sign off the press release and suggest any additions.
Thank you. So was there any other questions from members on the questionnaire at this time? Okay, we'll move on now to the Appendix 1, streamlined evictions. Just to explain to the public, could one of the officers please explain to the public in layman's terms what streamlined evictions are? Who would like to answer that question? Charlie, yeah, thank you.
Thank you, Chair. Charlie Haggerty, Legal Manager. Pardon me. A streamlined eviction is an eviction procedure which is allowed in circumstances where there has been a relevant criminal offence connected to the tenancy. So an example would be where somebody is dealing drugs would be probably the most pertinent example from the tenancy, in which affects obviously the neighbours, and in those circumstances registered social landlords are allowed to take a court action which treats that conviction as effectively a breach of the tenancy. So there's no need to establish the breach of the tenancy in those court proceedings. So it then just decides, the court just has to decide whether the actions of eviction is proportionate and follows the guidance which has been published by the Scottish Government.
Thank you. I'm of the understanding Stirling Council doesn't currently have a streamlined eviction policy. Could you tell me, could one of the officers please tell me why we don't have one, and has one been considered before, and why was it not implemented at that time?
Sorry, I'm not sure whether Stephen wants to come in here.
Yeah.
Sorry, Councillor. No, I was only going to say that I don't have the answer as to, I don't think the council has a policy, but I don't have the answer as to why it doesn't have a policy, and I'm not sure whether Stephen has that answer too, but he can confirm.
Thank you. Stephen, could you come in there, please? Thanks.
Yeah, I mean, I think the service would be open to having a policy on streamlined evictions. It might be a policy that would encompass our approach to evictions in general. It's something that we were made aware of in terms of streamlined evictions in the middle of last year, but it's not something that has gone to a policy, which doesn't mean that we wouldn't undertake a streamlined evictions without having a policy on it, but it would probably be, I could certainly see the benefits of it for both staff, tenants and elected members if we did have a policy in this area so people knew what we were able to do. So as I say, I'm open to looking at that.
Would there be any disadvantages to Stirling Council if they did have that a policy, a streamlined evictions policy?
Charlie might be able to provide a response to that, but I don't see there being a disadvantage to us having a policy.
I think on the contrary, Chair, that would be welcome from my perspective in legal services, because it would be something that we could point to when these cases are raised in court, which would allow us to say, here is our policy, this is the procedure which we had set down, which flows from the policy, and this is what we've done, which shows that we have met those standards. And I think if you refer to the case which I provided in the documentation for today, it's clear that what that case turned on in the Sheriff Court Appeal Court was the landlord's adherence to the policy, and to show that they had made reference to it, not as a checklist, not as, you know, you must do this, then this, then this, then this, but that they'd taken it all into consideration when they came to the decision to evict that particular tenant. And for me, that's a safeguard both for the tenant, and it's also a safeguard for the council, to make sure that when these types of proceedings are considered, they're considered appropriately and lawfully, obviously.
Thank you. Councillor McPherson.
Yeah, thanks, Maureen. Yeah, I'm pleased to hear that officers are going to be supportive of it, because I think there's some of the fine, if you're going to report to council on this, I think the whole thrust of this, the reason for setting up the scrutiny panel, and you and I, Maureen, have been doing joint casework with our case in Bannockburn, and I really do think that we need a policy. And Oak Tree Housing Association have it here in the papers. I see Homes for Life have got one, and it's very, very clear. And the case law, or the case precedent Charlie's put in that paper as well, I thought was very helpful as well, to be honest with you, because my understanding, as somebody, as I said previously, sat in the Sheriff Court and listened to hearings on it, if we get the process wrong, the Sheriff's just going to refuse the decree. So I think that us have a clear policy on it, that our officials, you know, instigate and implement, it'll make it far more simpler. And so I think the findings there, scrutiny is going to be key. A key part of this is the streamlined evictions, adopting a policy on it as soon as possible. Thank you.
Yeah, thank you. I do agree with what Councillor McPherson has just said, and I am pleased that the officers are going to consider implementing this policy. I just wanted to ask, the Homes for Life and the Oak Tree Housing examples that are given, are these robust policies, and would they be challengeable in court if Stirling Council was to implement a similar policy?
I'll take that one again, Chair. Yes, they are robust policies, because what they effectively do is they put into the localised context the Scottish Government guidance on how you undertake an eviction, a streamlined eviction. So we would be looking to do something which would be roughly similar to that. You can never rule out challenge, as you know. But the thing is about policy is that it is a different beast to the action of eviction. So the type of challenge that you would face for having an unlawful policy is different from the type of challenge you would face during the defence to an eviction process. It's much more difficult to challenge a policy, is probably the easiest way to say it. So if we get it right, it tends to be quite robust.
Thank you. Councillor Tomar.
Okay, thank you. I'm slightly interested in if it's not the tenant who is the person who's engaging in an activity leading to eviction, but a person who's visited the property. And I have a question about the lease that people get. Is there in a lease a clause which says to the tenant, in the case of the council house or other houses, that this particular thing in council lease that talks about other people visiting the property and their responsibility as the tenant? Because a defence could be that I didn't know this person was activity and getting involved in this activity. So is there something that in the case of going to an eviction, go back to show that there's evidence within the lease to say this is okay, prohibited, not just for the tenant, but a person who wants to visit or is relation of, or whatever the connection actually happens to be.
Thank you. Charlie, do you want to come in there? Yeah.
Thank you, Chair. Thank you, Councillor Tolamash. There's actually a case ongoing just now, I think, which is exactly on point. And it's, I won't name the council, but we provided some information from other councils as to how they are approaching these things. And the situation in that case appears to be that the parents or the tenants and a dependent has been convicted of a drugs offence, or drug dealing offence, possession with intent to supply offence, and what it's going to proof on is whether it's appropriate or proportionate to evict the tenants when they're saying they had no knowledge of the activity of the dependent, which is exactly the point which you mentioned. I think it's always going to come down to that. I think it would be very difficult to say that you can be evicted for something which is not within your knowledge. So knowledge is the key. If you can show that there's an understanding, or that the tenant knows what's going on and condones or allows it to happen, then that's one thing. I think if the tenant can successfully say, "Well, I had no clue," then that's another. And I think we do possibly have a local example of something like that. Now, I don't want to go into name names or to discuss that in too much details here. It's probably there's probably issues which would prevent us from doing that.
Yes.
But these are the very tricky questions which come out of this, councillor, and I think it all turns on knowledge.
Thank you.
Thank you. I also wanted to. I'll let Councillor McPherson and Councillor Flanagan come in a minute. I wanted to raise on page 44 of the agenda the Scottish Government guidance that's been given. It specifically mentions cases where there's someone being convicted of domestic abuse, and then they discuss how the family could be evicted because of the person who's been abusing them. Now, that really does concerns me that this legislation could be used in that way. In what circumstances would Stirling Council not evict somebody where a family member or a tenant has been convicted of a criminal offence? Because I wouldn't want a family to be evicted who has already been subjected to domestic abuse. Would you be able to answer that, please, Stephen?
I'm not sure I'll be able to answer that query on the spot. I'd have to come back with you with a response once I've had a look at the guidance in terms of that.
Okay, thank you. Who was first? I think Councillor McPherson, you were first.
Yeah, thanks, Chair. Yeah, I think that, well, I don't know if this one's probably for Charlie here. It's great. It'd be good to have a policy, right? I would like to know how we interact with the police, because ultimately our housing officers can only take, complaints from elected members and local residents about the allegations of it. But once, I suppose, if somebody's been given a conviction, that's done. That triggers this policy. Is that the process, Charlie? So if a tenant goes to court, I just need to get my head around the process here. There's a complaint, they go to court, there's a conviction. How did the housing service interact with the judiciary or the police in that matter for evidence gathering? Explain a wee bit to me how the process would work in that.
Thank you, Councillor. I think that's possibly one for Stephen to respond to rather than myself, because I don't know whether there's linkage in between housing officers and the police.
Thanks, Charlie. It's actually one more for Dan Hartles, who I see is on the call, in terms of how they gather evidence in relation to this. So maybe Dan could speak to this, if that's all right.
Dan, do you want to come in? Thank you.
Thanks, Chair. Thanks for the question, Councillor McPherson. Yes, we have very strong operational links with the police at a number of levels. So we're developing at an officer level, so community police officer to ASB investigation officer and housing officer. That piece of work is ongoing at the moment. I have very good links with the area command team, both on a multi-agency level. So there's a regular multi-agency meeting which occurs with partners where individual cases are discussed. In terms of information sharing, the council has an information sharing process and a protocol in place with Police Scotland, which allows us to get this information in a timely manner. There's also a piece of work ongoing directly with Scottish Court Tribunal Service at the moment around how the council can access information about ongoing cases with various constraints in place, such as delays due to COVID and the backlog of criminal cases at the moment. But that's also a piece of work that we're investigating at the moment. The police are very good at sharing information with us when they get that. We have a very good process of sharing intelligence and information with the police as well directly. So speaking on behalf of the police, and another area commander would say the same thing, we do have a very strong relationship with the local team in Stirling, and then we also have quite a robust process about how we securely share that information between both agencies.
Chair, can I come back on that very briefly, right? You know, so Dan, so you're confident.
Yeah, that's fine.
So Dan, you're confident then that if there is a successful conviction, somebody's imprisoned, in the current setup, how quickly are housing officers told about it, and how quickly could they instigate eviction or terminating the tenancy? Because if they're going to imprison, they're going to imprison. But the grey area is if they're put in remand. So there's a lot of grey areas in there, you know.
Thanks, Councillor. Apologies, I didn't introduce myself. Dan Hartle's team leader for community safety. So I'm confident in the information sharing that we have between ourselves and the police, and that happens on a daily basis. When the police are made aware of it, they do pass that on very quickly, and likewise, when we are made aware of it, we will query that with the police very quickly. And again, you know, we have contact with the police on a daily basis, if not more frequently than that in some cases. In terms of remand, yeah, that is a slightly more complicated matter. And again, I may defer to Charlie around the remand side of it, but remand is slightly different to a conviction where there's a custodial sentence imposed. In relation to how quickly then we can take action, that does vary based on a variety of factors. When we're told about the information, again, there's a regular meeting with legal services where we pick up these cases that we know are coming forwards, and then also discuss cases where we've had information that's come through. And again, it just then depends on the evidence that we have, and then when we can get an available time with the court, and that is very much dependent on the court diary.
Thank you.
Thank you. Councillor Flanagan, did you want to go in there?
Yeah, just a kind of comment, but if people want to kind of want to come in and discuss it. So I think when I seen the Scottish Government guidance, I was a bit sceptical before I read it that it was going to probably be a bit woolly and not very committal. And when I read it, I actually got the opposite impression from it. And actually, in the first, I think something was raised there about should people, you know, lose their home because of the actions of their dependents. It says very clearly in the guidance that as the tenant, you are responsible for the behaviour and actions of anybody inside your property. So there's, I think with this, I think this is something that we should embrace. Having read the guidance, I can't see anything obvious which I think should dissuade us from having a policy on this. And one of the things I would say is that I don't believe, me personally, us having a process or something to streamline the eviction of someone committing crimes, it's not. I don't view it as a deterrent to the people. I think they're going to commit crimes regardless. For me, this is about reassuring neighbours that actually, and the victims of these crimes, that actually it's regardless of whether the person is put off committing the crimes, the council will take action to remove these people for your own protection. And that's the kind of big thing for myself here, is that, you know, I'm all about making sure it's the victims of this and the kind of people who pay the taxes, live law-abiding citizens. They understand that we are following the guidance and we're not going to allow someone to basically disrupt the system on technicalities to try and stop them from being evicted effectively. That we will not rest effectively until these people who ruin, let's say what happens, ruin the lives of their neighbours, are evicted from their homes. So I think we should embrace the guidance, and anything we can do to make the process more streamlined, I completely support.
Thank you. I do agree with everything you just said there, apart from one thing, that if someone is evicted and someone is put in prison or convicted of domestic abuse, then the family shouldn't lose their home over it. That's the only thing that I
sorry, Maureen, I think that, yeah, absolutely. I think that's, yeah. I think what I was meaning.
I knew you meant that as well, but you didn't say that.
We're agreeing on the same thing, but yeah, absolutely.
That's okay. It's no problem. Right, Councillor Davis, do you want to go next? Thank you.
Yeah, thanks. Sorry, this is a bit of a dark question. Can I just get my head around what happens to someone who is evicted, whether speedily or not, in terms of if it doesn't go straight to prison? What responsibilities does the council have towards him or her in terms of housing?
It depends on the case, really, Councillor Davies. You know, we've in the past we've evicted people, and then we've undertaken a homeless assessment for that person, and concluded that they've made themselves intentionally homeless. So we wouldn't then consider ourselves to have a duty to provide housing for that person, though we might find ourselves providing temporary accommodation to that person for an interim period, and also providing advice and assistance in order that they can find some alternative form of accommodation. But in many cases, if we would classify them as making themselves intentionally homeless, but it will vary from case to case. So I wouldn't say that it's a blanket approach in every circumstance, but that's an example I'm giving you there, and that I would say that is, to my understanding, the way the majority of cases would go. Daniel may have or Charlie might have a different view, or might be able to provide some further examples potentially.
So just on that then, so does that mean if someone makes himself intentionally homeless, that the council washes its hands of that person?
In terms of they've made themselves, yeah, we don't have a duty to house homeless households if they've made themselves intentionally homeless in some way. And in this sort of case, if somebody's not heeded warnings about evictions, or a risk of eviction, or not amended their behaviours, they could make themselves intentionally homeless, and we wouldn't then judge ourselves as having a duty to provide accommodation to that household. So that, I'm not going to say that happens in every occasion, but it has happened in some occasions, to my understanding.
So how long would that prohibition last for?
I'm not sure. I'd have to get some clarification. I'd have to check that out. But I'm aware of, there's a couple of cases that I'm aware of that has been the approach we've taken, and it might be that we provide assistance for them to find something like a private let, in order that they're not, that they're not in a position where they're rough sleeping or anything like that. Because certainly that's something we definitely want to avoid. So we do provide advice and assistance, but we won't provide accommodation. But as I say, it will vary depending on the case. So I could potentially go away and provide some more information. It's difficult in terms of, that there's only a few cases in recent history. So we'd have to go a bit further back to look at some of the outcomes for those that have been evicted.
Yeah, okay, but presumably if this policy was to be pursued, that there would be more. If streamlined evictions would become more common, then presumably there would be more people in the situation.
It's really dependent on the basis of the case. I don't know. Because with us not having a policy at the moment doesn't mean that we wouldn't undertake a streamlined eviction. So I'm not sure whether there'd definitely be more evictions as a result of this. I'm not sure if, Charlie, if you want to give a view on that.
Charlie, do you want to come in there?
Thank you, Chair. No, I've not really anything to add to what Stephen has just said. I think part of the problem here, Councillor Davies, is that there has been more or less a moratorium in court cases, so we don't really know where we are with a lot of or what the effect is going to be on when these streamlined evictions are really brought in across all authorities or all registered social landlords. So we are a little bit in the dark as to what the effect is going to be when it is properly embedded in as part of everybody's procedures and when cases start coming forward. I mean, we have spoke to a number of our other colleagues in other authorities, and we've been told that there's only been a handful in each authority of these, if any. And by a handful, I'm talking about, no more than 5 in each authority since 2019. Now, normally you would have expected there to be many more than that, given that we've had the moratorium on evictions during the first lockdown. That's kind of skewed the position slightly, so we're not really sure what the true position is, and we won't know until things actually get back to normal again, and it looks as though things are getting back to normal in this context. So perhaps in 6 months to a year we'll have a better picture, but we just simply don't have that now.
Okay.
Thank you. Councillor McPherson.
Yeah, thanks, Chair. Yeah, I'll be quite honest, I sincerely hope there are more evictions for it, because we should never underestimate how drug dealing from tenancies blights communities. It completely destroys communities, and the frustration, as Councillor Flanagan said, that that law-abiding citizens suffer is just horrendous. So, no, I would hope we can have a policy in place as soon as practically possible for this. I think and we shouldn't just focus on drug dealing here. I'm looking at the examples of behaviour, Charlie, or Stephen, on the Oak Housing Association. We've got obviously breaches of antisocial behaviour orders, and one that really jumps out to me is the threatening and abusive behaviour, which can be really, really profound for people. So I think it's important we just don't focus on drug dealing here, because there are other elements of antisocial behaviour that really need, this policy. And in relation to what Charlie says there, yeah, you're probably right, Charlie, that COVID and the way the court system working are probably skewed things, but there is government guidance here now, and I suspect that other local authorities haven't followed through the guidance with a policy. I might be wrong in saying that, but that would be my suspicion here. But let's lead for the front and Stirling have a policy, zero tolerance where possible, and to try and improve people's lives, because that's what we're elected to do.
Absolutely. Charlie, did you want to come in there?
Thank you, Chair. Just in response to Councillor McPherson, from the information that we have, we see Highland Council have updated their policy to incorporate the statutory guidance. North Lanarkshire don't have a written policy just now. South Lanarkshire are revising their ASB policy to include the use of streamlined eviction procedures, and I don't think we have that information for anyone else. So from those who have come back to us, 2 out of 3 are either have or are in the process of introducing something that we are discussing today.
Good.
Thank you. Councillor Chalmers.
Okay, thank you. Going back to Councillor McPherson's, it must be continued antisocial behaviour, and I kind of feel also when we do these kind of documents, it's the information from the neighbours about what the process is, because I think often when we get complaints from neighbours and we go back to them, they get extremely frustrated about the length of time. So it's also not just about process, it's about the length of the time. Now, clearly, you need to have due process, but can that be explained? We agree to this. Okay, I'm very much in favour that we do, that we have timelines, because I think that's the biggest frustration that I've come back with the cases that have come to me, is it just seems to drag on and on and on. So where's the timeline? So any policy we put in place, council, it must have timeline that people can understand.
Thank you. Charlie, did you want to answer that?
Thank you, Chair. Thank you, Councillor Thomas. In respect of a streamlined eviction, the streamlined aspect of it is the tenancy breach has already been found to have happened. That's the conviction is effectively the breach of the tenancy. So there is there's no need for say like Dan and his team to go in and to conduct all these investigations, which may have to take place at, for use of a word, antisocial hours, night times, to see to try and catch the behaviour as it is happening, or there's no need for these long periods where people have to provide evidence over a period of time in an antisocial diary, for instance, which lists the events. So that all goes, because the conviction itself is the breach of the tenancy. So if we are going to be using these more often, then it would be hoped that they would be speedier because of that. So all you're left with is the decision to take, to check or to review the behaviour, the conviction against the guidelines, to see, to go through that process to ascertain whether it's proportionate to conduct the eviction or to go for the eviction in court. So you take away half, perhaps, of the process.
Okay, I understand that. So are we?
Sorry, Councillor Tomac. It's also written in the guidelines that it must be done within 12 months of the conviction, as well. I noticed that.
Okay,
carry on.
The question I have then is, going back to Councillor McPherson, that says this: if it's just conviction we're talking about, one of the biggest things is continued, persistent antisocial behaviour, which may not lead to a conviction because of the evidence to do with that. So are we now saying that this type of eviction can only be used for convictions? It can't be used for anything else then?
Yes, Councillor, that's correct. It has to be a conviction in and around the tenancy associated, of a relevant nature. So yes, it has to be. If there would have to be the normal procedure for other types of behaviours, and maybe Dan can enlighten you on a bit more in what those would be and what the procedure would be around that.
Charlie, it's not just a conviction here, it's a conviction that's
punishable.
Councillor
McPherson.
Yes,
sorry.
Yeah. Sorry, I thought I'd
speak through the chair, please.
Apologies, I thought
No, you didn't put your hand up. I'll let you speak in a minute. Sorry.
Okay.
I just wanted to also emphasise that this wouldn't replace the antisocial behaviour policies that are in just now. We would still expect officers to deal with persistent antisocial behaviour and to engage with tenants and those experiencing the antisocial behaviour as well. They wouldn't just be relying on the court to get a conviction in order for the council to evict a tenant. It would be a tool that the council can use on top of the policies that they already have. That's my understanding of that. Councillor McPherson, do you want to come in now? Thank you.
Chair, thanks for that. Yeah, I think it's an important point. A conviction's not enough here. In my view, this policy only kicks in if it's punished by a prison sentence. So it's not a conviction doesn't work. That's not suffice. It's got to be a prison sentence attached to it. Maybe Dan can clarify that, or Charlie, that's my understanding it. So we need to be careful on the words we use here,
Who wants to answer that, Charlie or Dan?
Hi, Councillor Benson. I'm just having a quick look just to be absolutely clear before I commit the position, unless Dan knows it off by heart. There he goes, hands up.
Yeah, Dan, do you want to come in? Thank you.
Thanks, Chair. Charlie, I'm not going to say it. I know it off by heart. My recollection of it is it's a serious criminal offence that leads to, that could lead to prison, a prison sentence. That's my understanding. Charlie or I will be able to divert on that, but it's my understanding is it's a serious criminal offence that could result in a prison sentence being imposed. That's my understanding. I just wanted to possibly come back on Councillor Tolmac's point from earlier, if that's okay, Chair.
Yes, of course, Dan. Carry on.
Thank you. So, Councillor, yes, in relation to persistent behaviour that isn't or doesn't result in a criminal offence, yes, we still have a process for that. We still have the ability to follow the discretionary grounds under the Antisocial Behaviour Act 2004, which allows us to take action. What I would say is all of our action has to be reasonable and proportionate. So we always keep in contact with our complainers and explain to them what action we're taking as much as we can. What we don't do, what's previously happened, is we've gone in with a lot of information for people at first, and we often find that that can be difficult to manage an expectation then. So the team, certainly in the last 12 months, have started to adopt a slightly different approach where they will explain to somebody what's happened. They will explain what our options are moving forwards, but they won't necessarily on day one, for example, talk about evicting somebody, because that is something that is quite far down the process, potentially, depending on what's going on. But we always try and provide that contact back to the complainer to say, right, you've said this, we've gone and done this. So we've been out, we've spoken to your neighbour, we've issued them with a warning, for example. So we are giving people more information than we have done before, but we are conscious that we don't want to give everybody every step that we could do or every action that could occur, because quite often people then fixate on one particular action, and it makes it then very difficult for us to then have that conversation that says, I'm sorry, in this case, we're not going to be able to take that action at this point in time. We also, at the point of needing to go to court or potentially going to court, have to be able to demonstrate that our approach has been reasonable and proportionate, and it has to be staggered and escalated. So again, we would come under quite a lot of criticism from the court if we had gone out and immediately applied for eviction where there was no criminal involvement or conviction off the back of that, without going through a process, i.e. warnings. Now, it's very difficult for me to context, and I've been asked the question by various members before, how many warnings does somebody get before we'll take court action? That varies on a case-by-case basis. I am really clear with the team, though, that what we shouldn't be doing is issuing 7 final warnings, for example, because that isn't proportionate and it detracts from it. So there's a lot of work going on with the team at the moment. They've undergone quite a lot of training. Nationally, we've got a number of new officers that have come in with a lot of experience in other authorities. So we are definitely seeing returns in that. Sorry, that was quite a long answer to your question, but hopefully that answers it, Councillor.
Thanks, Dan. Charlie, did you want to follow that up?
Yeah, thank you, Chair. It's just to confirm what Dan had said. It's an offence punishable by imprisonment committed in or in the locality of the house. But what that doesn't mean is that there has to be a custodial sentence imposed. All that has to be is that the offence itself could potentially lead to a prison sentence. So there could be a lesser disposal, but it's still a relevant offence in those circumstances.
Thank you. Councillor McPherson.
Yeah, that's the kind of crux of the matter for me here, Chair. I'm looking at page 40 on the report at 2.1 here, and it says here, where there has been a conviction for an offence punishable by imprisonment. So now what Charlie's saying there, that's not necessarily the case. That's not my reading it, Charlie. So I think this is a really, really important matter. You know, what's the trigger here? Is it a
Chair, could I come back on that point? If you look at paragraph 2.4, which is just underneath the bit you're looking at, I think, it clarifies what it means by an offence punishable by imprisonment.
Yeah, right, okay, no, it's fine. No, the end of that, I think this is obviously going to have to go through the committee process anyway. I just wonder whether or not the Public Safety Committee is going to have a role in this as well, because obviously the police sit in that as well. And, you know, I know Charlie had said earlier on that obviously there's a lot of information sharing and meetings with the police, but I think the Public Safety Committee has a role overseeing this and scrutinising this policy too, Chair.
Okay, well, that can be considered by the officers, whichever committee they say that it should go to. I would suggest that this is first remitted to HAG, the Housing Advisory Group, for their consideration and discussion, and also to the Stirling Tenants Assembly for their consideration. Would anybody disagree with that? Any elected members disagree with that? Is that okay?
Sorry to keep butting in here, but I just think that the governance side, this is really important. As somebody, you know, I've been councillor for 15 years, and I know the process here. You know, my understanding of the governance side of things, I need to get my head around this, is that this is going to HAG anyway. So, you know, the report comes from this panel to the full council. At which point the Stirling Tenants Assembly, who have representatives on HAG, I don't know how that'll interact. Maybe Stephen Clark can tell us, because we did discuss at one point having the TPAS involved here as well. Stephen, what's your view of the governance process this should take?
Yeah, I'd made a suggestion via email a few days ago in relation to this, because it is part of the motion that HAG are involved in the work of this group. I think what I'd be suggesting is that we facilitate a meeting just with the tenant members of HAG. HAG is a member, an elected member and tenants group, but obviously there's different elected members sitting on the HAG than sit on panel. So it makes it complicated to try and involve those elected members too, but we could focus it specifically on the tenants that attend HAG. All of whom are members of the Stirling Tenants Assembly, and basically we could provide them with an overview of what has been discussed at this group, talk to them about streamlined evictions, talk to them about sensitive lettings policies and other changes to the allocation policy. We could facilitate discussion potentially involving the Independent Tenant Participation Officer, and then provide a short briefing back to this group in terms of their views about the things that we've been discussing at this meeting. So I would suggest that maybe this is the way we want to do it, but I'm happy to take on board, board views of the panel.
Yeah, thank you, Stephen. I would agree with what you just proposed there. Councillor McPherson, did you want to come back there?
No, I think we've got to trust Stephen's judgment on this as an experienced housing officer, senior housing officer. So I'm happy to back Stephen in that 100%.
Okay, thank you. So we'll ask officers to take this forward onto HAG and the tenant members, as Stephen's just suggested. Yeah. Are we happy to move on to the next part, the sensitive lettings paper? Or does anyone have any other questions about the streamlined evictions or any other comments? Charlie, did you want to come in there?
Yeah, thank you, Chair. I suppose it's just to wrap up this part of the discussion, just to be clear what it is you're asking officers to do for the next, either for the next meeting when that we have, or for Bryony when she's writing the report. Are you wanting, in relation to streamlined, or are we going to wait until we speak to HAG to get their views on streamlined? It's just so that we're clear as to what it is you're looking for us to do for the next meeting. That was all.
Okay. Well, it's my understanding that Stephen is going to convene a special meeting of HAG just to discuss the issues that we have discussed at the scrutiny panel. Is that correct, Stephen?
Yes. Yeah.
Okay, thank you. Sorry, I didn't pick that up entirely.
He's going to bring back the findings from the special HAG meeting to the next meeting of the scrutiny panel. That's my understanding. I'm sure somebody will tell me if I'm wrong. So we'll move on now to the allocations policy, the sensitive lets. I think Stephen McCabe is on the call just now. Is Stephen on the call? And he can speak to the paper, the Appendix 2 that he's submitted. Thank you.
Yes. Thank you, Chair. And just to introduce myself, I'm Stephen McCabe, the Housing Allocations Team Leader. So the paper essentially provides an overview of the legal framework and guidance on sensitive lets, as well as a few other changes that could be considered being made to the housing allocations policy that could help to tackle antisocial behaviour. So sensitive lets, first off, they're a way to allocate individual properties to help ensure that the let leads to a sustainable tenancy and that any housing management issues are minimised. And essentially that involves giving consideration to the suitability of the person at the top of the list when we're letting a property based on the information that we know about that applicant, the property that we're letting, and also the surrounding area. It should, and sensitive lets should only be used for individual properties rather than being a blanket approach to lettings, because we do have the allocations policy, which is our approach to letting council properties. But we can have a sensitive lettings policy as long as there are clear reasons and processes that we set out that should be followed. And at section 2.4 of the appendix, there are some examples of sensitive lettings from other social landlords across Scotland that we've put in there to give you an indication of how this might look in an allocations policy. The one thing to note with sensitive lettings is that they're generally used in exceptional circumstances, and there are kind of clear boundaries as to when we might use a sensitive letting process. And most of the examples there, they do talk about antisocial behaviour, and they talk about using a sensitive lettings process when the previous tenant of a property has been responsible for antisocial behaviour, or the person at the top of the list has previously been responsible for antisocial behaviour. The paper then moves on to other changes that we might consider to the housing allocations policy as part of the annual review. The first change is potentially looking at increasing the suspension period of anyone responsible for serious antisocial behaviour. Currently that's a 12-month suspension, but we could increase that up to a maximum period of 3 years. And the second potential change that I've noted is that we could also consider introducing priority for people who are victims of abuse or harassment. And we could do this in two ways. One is to introduce harassment points into the housing allocations policy. And the second way of doing that is for more serious cases. I know that in the previous meetings we've said that we could prioritise serious cases through the strategic group, but we could put a section in there to explicitly say that that is what we would consider rather than doing it through an exceptional circumstances clause as well. Sorry, Chair, that's a fairly lengthy answer, but I think it gives an overview of the...
That's no problem, Stephen. Thank you very much. I do agree that there should be points allocated to people who have experienced antisocial behaviour and who want to move property. I do agree that that should be, and I really would like that to be discussed at HAG as well in the meeting that Stephen is going to organise for us. And I also agree that there should be a sensitive lets policy in place, but I do think that there needs to be strict criteria when that's in place. I noticed that Link Housing has set out some quite strict criteria there, and I think that something suitable like that would be good for Stirling Council to have. Does any members have any questions on this appendix here? No. I wanted to make a comment.
Chair, I've got my hand up.
Oh, sorry, Alistair, I didn't see you there. On you go.
Yeah.
Thank you.
Stephen, thanks for your introduction to that. The 2 or 3 things in here. Is there Scottish Government guidance on sensitive lets, or is it all kind of rolled into the allocations policies and such like? Is there any clear-cut government guidance like there was in the the Let's one we just talked about?
Yes, there is. So the Scottish Government have produced a document that is guidance on social housing allocations in Scotland. So there is a section within that that gives guidance on sensitive lets and how it should be used in the allocations policy. I think there may be a link within the document to that guidance paper.
I clicked. It's a dead link.
Apologies. We can send the proper link round.
No, that's really great. I would have expected that to have been part of the appendix. I know the link's there, but you know the fact that it's a dead link is quite unhelpful, to be honest with Stephen. But at the end of the day, no, we need to see what the Scottish Government guidance is on it. To be honest with you, you would like to think it's been through Parliament and been scrutinised through the parliamentary process. So you know, if you can do that, that would be helpful. I think that the key thing here I've got here, Chair, is that, and based on casework in the past here, it's this lifestyle clashes. And I can clearly remember 2 or 3 years ago, a block of 4 in Flynn, 3 elderly people, long-term tenants in there, and then they put a young person at the 4th flat who partied all night. It was absolute chaos and created enormous upset for the family. So how we got that one spectacularly wrong, I do not know. But, you know, there's no point in raising individual cases here. But, Stephen, it concerns me here that you're saying that we could do this in relation to giving points for harassment, for instance. Surely we should be doing that anyway. You said I wrote it down as you said it. We could give more points for people suffering from harassment. Why are we not doing that anyway?
So it is something that we consulted on as part of the allocation policy review in 2019. And at that time, the majority of respondents to the consultation agreed that it is something that we should look at. But in terms of ranking, it was one of the lower ranked priorities of respondents to that consultation. I think at that time, there were major changes that were required to the allocations policy just to make sure that it complied with legislation. And what we focused on was the major changes to make sure that we're compliant with the 2014 Housing Act, and the harassment points weren't introduced at that time. But it's certainly something that we want to consult on as part of the annual review of the policy, and certainly we'll look to introduce them and take that proposal to HAG and to committee this year, as part of the review.
Okay, Chair, I think the last thing I'd say was in relation to your comments about providing points as well. Agreement in principle, I think that's going to be fraught with difficulty. You know, and then Stephen McCabe mentioned clear boundaries as well. That was a statement he made as well. I do not know how you're going to award points and what's the threshold, what threshold has to be met to award it. I don't know how that's going to work in practice, and maybe Stephen Clark could maybe comment on that one. I think it's a good suggestion. I don't know how it would work in practice.
Thanks for your question, Councillor McPherson. Yeah, there's no doubt about it. It does place more of a pressure on the lettings team in able to try and determine how to fairly award these points. Requires work with community safety colleagues and Police Scotland as well in terms of where the appropriateness of applying points. So it does provide more difficulties, but it still feels like it's something that we should be doing. Incidentally, I've just clicked on the link there in terms of the policy. It's working on my browser, so it might just be worth giving that a try again, Councillor McPherson. And just in terms of sensitive lets, you know, that does make it more difficult for letting officers to do the jobs and shortlist people. It will also cause some complaints because you could very well have an occasion where somebody is aware that they're first in an area, but we're not going to let them a property because it's not in accordance with the sensitive let that we've got. So, you know, we would likely get some criticism from tenants or prospective tenants in relation to that. However, you know, there are advantages to having such a policy. I think that we might want to introduce it, but it's not going to be without its pitfalls. There's no doubt about it.
I think if there's a robust criteria and a robust policy, then you know, there will be complaints anyway, but I do think it's important that this policy is at least considered and discussed by HAG and by the Tenants Association as well. Charlie, did you want to come in there?
Yes, thank you, Chair. It was just a kind of a brief point on that. It may be possible to amend the allocations policy to say that it has to be read subject to the the subsequent policy, so that people are aware of the fact that because you're top of that list doesn't mean automatically you're going to get the next house which comes up, because the sensitive allocations policy may come in. So it's just a comment on that. That's all.
Thank you. Councillor Chalmers, did you want to come in?
Yes, I did. Okay, thanks, Chair. A little bit back to what Stephen was saying. In the page 52 in Edinburgh, if you look at the bottom of their criteria, and any other criteria where the local housing and regeneration managers can evidence that an application is not suitable for the offer, please, can I say, if we have one in Stirling, we do not include that, because that puts a huge off. If this has a lot of other clauses, if the officers are using a clause which is not robust and they can't evidence it without saying what it is, I think that would be very dubious. So we need to protect our staff, that when they're going through a process that they can actually defend it. And to have a clause like that sounds a bit on the dubious side.
It's just to respond to you, Councillor Tolomash, yeah, well, it's something that we'd certainly look at, going through the period of consultation in terms of what would be workable for us to introduce if we were to introduce a sensitive lets policy. Thank you.
Thank you. I wanted to raise the on page 54, Stephen, you've made mention about probationary tenancies. And on reading it, I did actually think that sounded, as if it would be an advantage to Stirling Council and to Stirling Council's tenants if that was something that Stirling Council would be able to implement. But then I read at the end that the Scottish Government did not include probationary tenancies in the housing bill that was introduced to Parliament, and this was following opposition by Shelter. I do think that because Stirling Council isn't allowed to introduce probationary tenancies, it's Stirling Council's housing. They should be allowed to implement probationary tenancies if that's what they see fit for their properties. And I do think that probationary tenancies would be an advantage to particularly first-time tenants, ones who's never run a household before. They would not just be able to get assistance with how to be a good neighbour, but support on things like money management and paying your bills and things like that, because a lot of people who have first-time tenancies don't have any understanding of how to run a household, how to pay bills and things like that. So I think that probationary tenancies would have been an advantage to council tenants, particularly the first-time tenants. I was just wondering if any officers want to give any comments on that, and if they feel that they would be an advantage to Stirling Council tenants. Sorry, Stephen, on you go.
Thank you, Chair. I think you're right. I think that probationary tenancies, that there were a lot of positive aspects to the introduction of probationary tenancies in some of the situations that you've outlined there. It potentially would have given us an opportunity to provide people with support to ensure that they would sustain a tenancy. I think the difficulty that we've got now that the Scottish Government didn't enact that within the 2014 Housing Act is that we are constrained by legislation in terms of what tenancy agreement we can provide people, and there are limited circumstances under which we can provide short Scottish secure tenancies, which is what the probationary tenancies would have been. So we couldn't have a widespread use of those as envisaged by the suggestions that were being made. I don't know if the Scottish Government are planning on revisiting this or anything like that, but I do think there were certainly positives. I think Shelter opposed it because they viewed it as a kind of attack on tenants' rights, which is one view of it, but I do think there were certainly advantages as well.
Thank you. Is this something that you would be willing to raise, but that the council would be willing to raise with the Scottish Government again? Stephen Clark, maybe you want to answer.
We can certainly raise it as an issue. As I say, I'm not sure if there's any plans to review the legislation at the moment, but we can certainly raise it as an outcome, as a recommendation potentially from this panel, to query whether this would be reviewed again in light of comments from other councils, etc.
Thank you. Is there any other questions or comments on the appendix that Stephen McCabe has just talked to? Councillor Gibson.
Thanks. Yeah, just ask a question, just for the panel's benefit, the status of that within the allocations policy, because there's talk about it might be incorporated in the allocations policy. What's the standing of it at the moment, just for clarity, please, Stephen?
In terms of, sorry, streamline sensitive lets, are you querying that? Yeah, it's not within the current allocation policy, but that is, we're required to review the allocation policy every 12 months from the date of implementation. So it is coming up for review. So it is something that we can consult on to amend this summer when we've got the opportunity to do so, to bring forward recommendations. So that could be one of the recommendations, that we bring that forward to introduce that as part of the allocations policy going forward. But at the moment, there's no reference and there's no ability for us to undertake sensitive lets within the policy at the moment.
Thank you.
Thank you. I'll just go back to the recommendations on the report. I think we've... can we agree that the consultations with the Housing Advisory Group, as we've discussed already? Bryony, do you want to cover what's to be taken forward to the Housing Advisory Group, please?
Yes, thank you. We were to look to agree to go ahead with a meeting with the Housing Advisory Group as part of our consultation to inform the work of the panel. And from memory, but others may be able to add to this today, in our discussions we've discussed 2 different items in particular that would be, and really that's about the discussions we've had today, both about streamlined evictions and sensitive lets, and to get the views of the tenants, particularly on that group, in order to bring that back to the panel at the next meeting. So that would be actions following this meeting. I'm not sure if there was anything else in particular.
There was also the, on page 53, the other possible changes, and we wanted that taken forward to the Housing Advisory Group as well. Do you think it would be worthwhile asking HAG for their views on probationary tenancies? That's the councillors I'm asking.
Yeah.
Anybody? Yes.
I don't see why not. Yeah.
Yeah. Shall we do that as well? Can we ask HAG for their views on probationary tenancies as well, please?
Yes, we could do that.
Thank you. Danny, did you want to say something? You've got your hand up.
Sorry, legacy hand, as the phrase is. No, apologies.
Right, no problem. In regards to the questionnaire for the Engage Stirling, can we agree that the questions should be put out to the public and a press release put out as well to publicise it, and it should all go on social media channels to get as much awareness as possible that it's there? And we can also agree that the press release should be circulated to panel members for their comments.
Okay.
Okay. So was there any other questions or comments anyone wanted to make? Okay. So I think oh, sorry, Brian, on you go. Thank you.
Apologies in advance if you were just moving to this, but it was just for the beginning of consideration of our work towards a report, which obviously will be concluded in future meetings, but it was just if we were beginning to form some thoughts on that to help us take that work forward.
Well, would you like me as chair to meet with you, Brian, and we'll discuss it? Yeah. Is that okay? Is that okay with the members?
Be very helpful if that was a possibility.
Thank you. Was there anything else anyone wanted to raise?
No.
Right. Thank you. So thank you very much for meeting today, and the meeting's now closed. Thank you.
Okay, thank you, Maureen.
Thank you.
Thank you. Okay, bye-bye.
Thank you.